Hey everybody, Brett Thompson, Thompson Law Group, coming at you from our world headquarters here off of Bonnie Road in Virginia Beach. And this is going to be the Closing Ninja Classroom. So this is a video blog here. I'm going to try to put out some content ever so often in regards to different issues pertaining to real estate. It could be investors, real estate agents, first-time home buyers. We're going to just put some content out there that we think that might be valuable to you. So today's blog is going to be in regards to a lot of questions I get from investors. Should I put my property in an LLC? Should I put it in a different corporate entity? And there are pros and cons to that. There's a lot of pros, but you have to know about the cons as well. So number one, yeah, it's a good idea, okay? The most common corporate entity structure is the LLC, the Limited Liability Company. And we would do that by filing articles of organization with the State Corporation Commission. We would obtain a federal tax ID number for you. We would draft what's called an operating agreement, and we would get your articles of incorporation, operating agreement, federal tax ID number, and you would get a certificate of organization from the State Corporation Commission. Once you have all that, you can set up your bank account, and then we could, if the property is deeded in just your name, or you and your wife, we could then do a deed of gift from you individually into the LLC that you own, and there are certain code sections that pertaining to that kind of transfer that make it a non-taxable event. So there's only the clerk's fee for that. Here at Thompson Law Group, we probably represent over 200 different companies as the registered agent for various small businesses that we have incorporated, formed, sold. So we represent a lot of small business owners. Now, if you are mom and pop, individual, and you have a few different properties in your individual name, you have to understand that if there's a mortgage in place and you obtain that mortgage, and it's a 30-year kind of Freddie Mac, Fannie Mae product, there's going to be an acceleration clause in the deed of trust, which is the mortgage document, and that essentially says that if you convey any interest in the property to a third party, they can call the note, meaning that they can say it's all due and payable. So you have to be aware of that acceleration clause. It is legally permissible for the lender to call the note after that. Practically speaking, I've never seen it done in my practice, as long as the mortgage is being paid on time each month. I've never seen it happen, but it's possible. So you would sign a disclosure acknowledging that you understand that there is the acceleration clause. Some clients could try to contact their lender. I've never seen a situation where their lender, who is servicing a Freddie Mae, Fannie Mac 30-year product, I've never seen the lender agree to allowing the borrower to be the LLC or the corporate entity. So just be aware of that. So you do have the corporate veil there, meaning that it does separate you from your personal assets. So if you had a rental property and somebody fell and broke their neck, if the property was owned by an LLC and the lease was in the name of the LLC and you had your own bank account and you treated it as a separate company, an arm's length company transaction, then there is a lot of protections from your personal liability, such as they couldn't go after your personal bank account, your car, your house, things that are titled in your name. So it would limit your liability, hence the name Limited Liability Company. So there are a lot of pros, but there are also some cons that you need to know about. Feel free to contact us here at Thompson Law Group, 486-3333, and we can talk about the more intricacies of it. There are also some tax implications, which I would refer you to your accountant or your CPA in regards to the tax implications. But in a nutshell, that's LLCs and investment properties for